Hearing the appeal of the King and the application of Maguire against His Majesty Senior Coroner for Blackpool and Fylde and another.
Now, two preliminary matters. First of all, we're slightly late starting. That's because we've taken rather longer than we usually do to discuss the case in advance of the hearing. The second matter is we would prefer to have the deceased referred to as Miss Maguire. That seems more respectful than referring to her by her first name. So, Miss Richards. Oh, actually, a third matter. If there are members of the, there are certainly some members of the family, I think, here. It's important. They're the most important people in the courtroom, so it's important that they should be in a position where they can see and hear what's going on. So if they're not, please do come further forward.
They are, my lord, thank you. Mrs. Muriel Maguire, who I represent, who was Ms. Maguire's mother,
yes,
is here present today, as are two of Ms. Maguire's sisters.
Yeah. And
then Mr. Kenneth Maguire, who's an
yes,
interested party in his own right, sits to my left.
Yes,
I see. There are a number of members of the family here.
Fine. Okay. Well, thank you, Ms. Richards.
My lords, my lady, I propose to develop my submissions by reference to the three issues identified in the Statement of Facts and Issues in the order in which they appear. So I propose to look first at the nature and extent of the substantive obligations owed under Article 2, and that will involve consideration of some of the key authorities, both domestically and in Strasbourg. Secondly, I will address the court on whether there is an arguable case or credible suggestion that there was a breach of one or more of the substantive Article 2 obligations, such as to give rise to the procedural obligation. And thirdly, I will look at what the coroner was required to do and where we say the coroner went wrong. I'll then deal with some matters arising out of the Court of Appeal's judgment and some of the submissions advanced on behalf of the respondent.
So are your submissions proceeding on the basis that the existence of a procedural obligation is dependent on there being either a breach or an arguable breach of a substantive obligation?
Yes.
Right.
The case has never been advanced on the basis of what is sometimes referred to in the case law the automatic obligation, or the obligation arising automatically. There is case law specifically in relation to categories or subcategories of prisoners where that has been held to be the case. But we've never advanced the case on that basis, and I'm not proposing to do so today. I should say, just in relation to the issue of the procedural obligation automatically arising, there is a recent decision of the Court of Appeal in the case of Morahan, which I hope came to the court separately. It was too late to include in the bundles. I don't have any submissions to make about it. It's a very different case on its facts from the present case. But that was a case in which the automatic argument was advanced and fairly firmly rejected by the Court of Appeal. But before I turn to the Article 2 substantive obligation and the case law in relation to it, there are three aspects of Ms Maguire's position which in my submission are relevant to bear in mind when considering the authorities. So three interlinked circumstances. The first is the fact that she was deprived of her liberty. The deprivation of liberty form is in the bundle at page 1887. There's no particular need to turn it up unless the court wishes to. That's the form which referred to the acid test articulated by Lady Hale in the Cheshire West case, under continuous supervision and control, not free to leave, being the hallmarks of a deprivation of liberty. And the reference to Lady Hale's judgment and the articulation of the acid test in Cheshire West is at pages 1949 to 1950 of the bundle, paragraphs 46 to 48 of the judgments in that case. Again, no need to turn it up. But Ms Maguire, deprived of her liberty, and the deprivation of liberty form at page 1887 applies in terms the acid test in Cheshire West and finds as a fact that Ms Maguire was not free to leave. She'd be prevented from doing so if she tried, and she was under constant and continuous supervision and control. The second aspect of Ms Maguire's circumstances, which we say are particularly relevant, is her vulnerability. Not an issue factually, but again for my lords and my ladies' reference, an assessment undertaken for the purposes of the deprivation of liberty authorisation at page 1894 describes Ms Maguire as harbouring multi-dimensional vulnerabilities. And she was vulnerable because of her learning disabilities and her consequent inability to look after herself. There is no dispute that she was someone in need of special care, support and protection. She was, moreover, someone who could not clearly communicate problems or symptoms. She could not make a capacitous decision to accept or reject medical intervention. And she could not take any steps to secure medical treatment or intervention for herself. Those are all aspects, we say, of her vulnerability. The third circumstance is assumption of responsibility. Ms Maguire was in the care of and under the control of the state. She was someone for whom the state had assumed responsibility. She was placed by a public body in a care home, which by virtue of the Care Act was discharging public functions for the purposes of the Human Rights Act. And the justification on the raison d'etre for such a deprivation of liberty was that she would be kept secure and safe, and in part the justification was that the home would ensure she had appropriate and timely access to NHS services. And that's said in terms at page 1888 of the bundle. I invite the court's attention just to that. This is part of the deprivation of liberty paperwork. And halfway down page 1888, there's a box in the form headed "The reasons for my opinion are," and then there's a passage beginning, "The home is a small residential unit." And halfway down that paragraph, the court will see reference to the home making sure she has appropriate and timely access to her GP and other NHS services. Those are the three factors: deprivation of liberty, vulnerability and assumption of responsibility, to bear in mind in our submission when we look at the most relevant authorities, rather than a label of hospital case or medical case.
Can I just ask you about being in the care of the state? Am I right in thinking that the care home is privately run?
It is.
So when you say in the care of the state, is that because it's discharging public functions under the Human Rights Act?
It's twofold, my lord. The first point is that she was placed in the care home by a public body, itself discharging functions under the Care Act, and she was deprived of her liberty in the care home pursuant to a standard authorisation granted by that same public body, the local authority. And then the second is the observation my lord makes, which is that the home itself, although in form a private provider, was discharging public functions for the purposes of the Human Rights Act. And that's by virtue of Section 73 of the Care Act. I'm sorry that that section's not in the court's papers. We could obviously provide it if necessary.
Is that the provision that was introduced after the YL case?
It is. Initially, it was introduced by route of an amendment to the Health and Social Care Act 2008, I think, and then that's been repealed, and the current provision is Section 73 of the Care Act 2014, essentially in identical form, and my lord's absolutely right, introduced following YL.
So, yes, at some point I think we probably should have that provided to
We
us.
can provide that, my lord.
Thank you.
Yeah, I'm not sure if we have that act in our bundle at all.
We don't, my lord. We can provide the relevant sections of the Care Act. I'm sorry for that omission. My lords and my lady, with that introduction, I turn to the substantive obligations under Article 2, and perhaps just start with a general point drawn from a decision of the House of Lords in Armine and the Secretary of State for the Home Department, That's in the primary authorities bundle, or section of the bundle. It should be page 1968. And if the court turns simply to page 1978, it's paragraph 18 in the judgment of Lord Bingham, picking it up between letters E and F, where he refers to Article 2 as one of the most fundamental provisions in the Convention, and then sets out just above F, the approach to interpretation of Article 2 must be guided by the fact that the object and purpose of the Convention as an instrument for the protection of individual human beings requires its provisions to be interpreted and applied so as to make its safeguards practical and effective. So that's the starting point in terms of the importance of Article 2. In relation to the substantive obligations that arise under Article 2, the positive substantive obligations, I should say, they've been described as two distinct, albeit related, positive obligations, and I take that description from the Grand Chamber's judgment in Fernandes de Oliveira and Portugal. No need at this precise moment to turn it up, although we will look at that authority, but it's paragraph 103, page 2668. And those two distinct, albeit related, positive obligations are usually referred to in the case law as the systemic duty and the operational duty. The systemic duty is variously described in the case law, not always in the clearest of terms. In Fernandes de Oliveira and Portugal, in that paragraph reference I just gave, paragraph 103, page 2668, the reference is to the need for a regulatory framework compelling hospitals to adopt appropriate measures for the protection of patients' lives. Obviously, hospitals applies because that was the concern in that particular case, but it's more generally expressed, obviously, in other cases. Perhaps the most pithy description is in the Divisional Court's judgment in Morahan. Again, no need to turn it up. It's page 2168, paragraph 30. That describes the systemic duty as meaning that you have effective administrative and regulatory systems in place. If my lords would turn, and my lady would turn, to page 2780 of the bundle.
Just before we do, when you cited Fernandes, you said that spoke about a regulatory framework. Where do we find in the Strasbourg case law an administrative framework?
We see it more by way of example than articulation. There are a handful of examples I'm going to provide the court, and it may be that I can provide a more precise reference. Certainly the case of Arskaya in Ukraine, which I'll come to shortly, uses the language of regulation.
Yes, well, the Fernandes case uses
I'm sorry,
of regulation.
Uses the language of... it's administrative. It's not, I think, articulated in using precisely that term in the case law, but some of the examples, which I propose to show the court in a moment, would, I think, more accurately be characterised as administrative rather than regulatory.
I mean, it's quite important because if there are deficiencies in the internal systems of a hospital, for example, that's not a regulatory failure. It's an internal failure. No.
Yes.
And you did give us the name of one case. Sorry, I just didn't note it. What was the case you referred to?
A moment ago, yes. Lopez de Sousa Fernandes.
No, there was one against Ukraine.
Yes, Arskaya and Ukraine, which I'll come back to. Arskaya, Arskaya, which begins at page 2519 of the bundle, but I'll come to that in a moment.
Thank you.
If the court would kindly go to page 2780. This is partway through the judgment of the Grand Chamber in Lopez de Sousa Fernandes in Portugal. The judgment starts on page 2736 of the bundle. But for present purposes, and just in terms of seeing, in general terms, an understanding of the systemic duty, if the court would look at page 2780, paragraph 189. You will see there the court saying it must, moreover, be emphasised that the state's obligation to regulate must be understood in a broader sense, which includes the duty to ensure the effective functioning of that regulatory framework. The regulatory duties thus encompass necessary measures to ensure implementation, including supervision and enforcement. So that's an aspect of the systemic duty.
Maybe that's the administrative part.
Yes, potentially. I will check to see whether there is any express use of the term administrative in the Strasbourg case law.
I mean, the context of this is perhaps seen at 186, where we're told that in the context of alleged medical negligence, the state's substantive positive obligations relating to medical treatment are limited to a duty to regulate. That's to say, a duty to put in place an effective regulatory framework compelling hospitals to adopt appropriate measures for the protection of patients' lives.
I understand there's some difficulty towards the back of the court in hearing.
Oh, I'm sorry. Sorry, I'll make sure now. I'm not sure if this is working. Yes. Yes.
Thank you.
Yes, I'm sorry. I'm afraid I managed to catch a cold over the weekend. Rather hoarse, but
That's
I'll try to
much
keep
better,
my voice up for you.
Obviously, I'll be coming back to Lopez de Sousa Fernandez because our primary submission in relation to this case is that it has no application in the context with which we are concerned. But just in terms of trying to get a general understanding of what's been said about the systemic obligation, my Lord rightly draws attention to paragraph 186. A requirement for hospitals to adopt appropriate measures a regulatory framework requiring hospitals to adopt appropriate measures for the protection of patients' lives, which is obviously a fairly general statement. And then we see over the page the reference to the need for there to be measures that ensure implementation and the effective functioning of that framework, including by way of supervision and enforcement. And that does, in my respectful submission, speak to more than the mere existence of a system of regulation in principle.
Yes, one sees further up that page, for example, at 184, this regulatory obligation is given quite a wide scope. I mean, they're discussing there a case where effectively somebody, well, the authorities, it said, were or ought to have been aware of serious problems affecting emergency medical treatment in a particular region. And I can imagine people, for example, being left in ambulances because there are no beds available. And that's treated in the last sentence as a structural issue linked to deficiencies in the regulatory framework.
Yes, and when one thinks back to the general observation of Lord Bingham in Armine, which obviously drew on Strasbourg authorities, one is reminded of the need to ensure that the obligations and the rights are given effect to in a way that's practical and effective.
Yeah.
And so we would respectfully suggest that even Lopez de Sousa Fernandez, which is looking at matters at a relatively high level and obviously not concerned with any operational duty, it is requiring that there be not merely the existence of a framework of regulation, but one which works in practice.
Well, I mean, 182, says the court has distinguished cases where there is an arguable claim of a denial of immediate emergency care from cases which concern allegations of mere medical negligence. So they're using, well, they're drawing, I mean, it's not a familiar distinction to us. So they're using medical negligence in a more restrictive sense than we would use it.
Yes, they are, undoubtedly. The term medical negligence appears to be used in the Strasbourg authorities as denoting essentially an individual or isolated error by a clinician or healthcare worker.
Well, even then, I mean, if there's an individual who is responsible for a denial of immediate emergency care, is that medical negligence, or is it not?
Well, it may well turn on the particular factual context, my lord. These cases, I'm afraid, at the Strasbourg level are not easy to understand precisely how they are intended to apply in individual cases. Systems are only operated ultimately, put in place and operated by individuals. The systems don't function in the abstract. They are given effect to by human beings.
But the reference there to denial of immediate emergency care, I think, is referring back to much more egregious sorts of cases where there really was a deliberate decision not to provide somebody with medical care who clearly needed it because they were a prisoner or because of something else.
Yes, the authorities they're referred to, I may need to check the first one that's referred to in the footnote 64, Centre.
If you look at 178, for example, they're referring to the doctor's refusal to carry out an urgent operation owing to the victim's inability to pay medical fees.
Yes, and AW, which is the second case referred to in the footnote, is the case that's then referred to again in paragraph 184. That was about there being inadequate, as I recall it, inadequate facilities for neonatal care in a particular area. So
but that's not this case.
It's not this case. No. And indeed, Lopez de Sousa Fernandez is not concerned, we say, with the circumstances with which this case is concerned. Just then trying to see how the systemic duty has been considered in a handful of individual cases. The first is a domestic case, the case of Humberstone, at page 2075 of the bundle. So that it's in fact page 2078, but if I just pick up the observation in paragraph 62 on page 2075, reference there between E and F, that the distinction drawn between individual and systemic neglect may be indistinct and there may be some overlap between the two. And then if we go to page 2078, paragraph 69 to 70, the court will see that what was held there to be at least an arguable case of a systemic failure, such as to give rise to the obligation for there to be an Article 2 compliant investigation, were concerns about the practical operation of the Yorkshire Ambulance Service. And picking it up about 5 lines from the top of the page, there's reference to delay in dispatching an ambulance, reference then to 2 possible explanations for that delay. One was about resources, essentially. Ambulances, all ambulances, save one except, were busy. And then the other explanation is about a paramedic not realising what the appropriate response was to the call. And then various other matters set out. And what the court there says, at paragraph 70, is that they're persuaded that this evidence not previously available does disclose sufficient grounds for concern about the resources and operational systems of the Yorkshire Ambulance Service as to engage the Article 2 obligation proactively to undertake an enhanced investigation. So that's one way in which the domestic courts have interpreted the Strasbourg jurisprudence and identified what might give rise to a systemic breach, at least necessitating the Article 2 compliant investigation. Turning then to the case which I referred to a few minutes ago, Arskea and Ukraine. court turns to page 2519 of the bundle, you will see the first page of the judgment. And then...
so what was the page number again? I'm sorry.
Page 2519
yes, thank you.
is where the judgment begins. The facts, I don't propose to read through them, but for the court's note, are set out on pages 2522 to 2523, paragraphs 6 to 18. They concern someone who had significant physical health needs, but there were issues about the provision of treatment arising as a result of the patient not giving consent to treatment, and questions about whether in truth the patient had the capacity to refuse consent. If the court turns to page 2537, I should perhaps pick it up at 2536. The heading, just above paragraph 84 on page 2536, is the obligation to ensure adequate healthcare regulations. And then, if the court looks first of all at paragraph 86, there's reference there to the inadequacy of the city healthcare regulations governing cooperation between the city hospitals in a situation where intensive medical care was only available in one city hospital. So that's one aspect that was being explored by the court in relation to adequate healthcare regulations. The second is on the next page. The court will see paragraph 87 refers to the domestic authority's reliance on the applicant's son's repeated refusals to consent to treatment. And then at paragraph 88, picking it up in the third line, the court says this: the court considers that the question of the validity of S's refusals to accept vitally important treatment should have been properly answered at the right time, namely before the medical staff refrained from pursuing the proposed treatment and relying on the patient's decision. And then if we skip down 4 lines, you will see the sentence beginning, to a large extent this key question was not duly addressed by the doctors during S's hospitalisation, because the domestic regulations in this field do not sufficiently elaborate on the conditions under which refusal to undergo treatment was valid and binding on medical staff. The present case suggests in particular that the regulatory framework did not adequately ensure that a patient's decision-making capacity was promptly and objectively established in the course of a fair and proper procedure. So that's a further example of a systemic failure, a system that didn't adequately ensure that there was a proper assessment of decision-making capacity before decisions taken not to provide treatment. And then, if the court goes to the Grand Chamber's decision in Fernandez de Oliveira, we can pick it up at page 2669 of the bundle. The judgment itself starts on page 2637. To put it in context, Fernandez de Oliveira is the case in which was effectively the Strasbourg court taking the same approach as this court had taken several years earlier in the case of Raybone. So it was a voluntary psychiatric patient case. And then we see at paragraph 107 on page 2669, the reference there, and this is under the broad heading at the top of the page, the positive obligation to put in place a regulatory framework. The question whether there's been a failure by the state to comply with its above-mentioned regulatory duties calls for a concrete rather than an abstract assessment of any alleged deficiency. The court's task is not normally to review the relevant law and practice in abstracto, but to determine whether the manner in which they were applied to or affected the applicant or the deceased gave rise to a violation of the Convention. And then there's
I thought this regulatory right applied, doesn't that apply to everybody, whether or not you're voluntarily detained?
Yes, it does.
Yeah.
Yes, my lady, the question mark is whether the operational duty applies.
Yes.
My lady's absolutely right. There's no dispute but that a systemic duty is owed to people, including people in the position of Ms Maguire. This is an attempt to understand what kind of approach the courts have taken.
It's not only to those people.
No, absolutely not. And then if the court goes to page 2671, you will see the heading application of those principles to the instant case, just below paragraph 115, and then the first section is entitled the positive obligation to put in place a regulatory framework. And what you will see is that the arguments that were advanced about a breach of the regulatory obligation related to lack of security fences and walls around the particular institution. And then over the page, paragraph 120, reference to the surveillance procedure in place for voluntary inpatients. Now, on its facts, the case did not succeed. The court was satisfied that those did not amount to breaches of the systemic obligation. But it may be instructed to see that the court didn't suggest that, in principle, those were not relevant to an understanding of what the systemic obligation was.
What was the regulatory framework breach in this case?
Oh, well, the claimed regulatory framework breach was the lack of security fences and walls.
No, in this appeal.
In this appeal?
Yes.
My Lord, I'll obviously come on to this in more detail, but a number of different systemic breaches that we identify. The first is the failure to have in place a system which would have produced in advance a care plan or process for ensuring that an incapacitated patient known to be unable to consent to going to hospital, known to have, on the particular facts of this case, a fear of going to hospital, a system that would ensure that there was a pre-identified means of getting them to hospital if an emergency need arose.
Even if that involved manhandling them, sedating them,
Absolutely.
restraining them.
Yes, absolutely. All perfectly lawful if undertaken in someone's best interests.
But I mean, in the sense that framework exists already. If someone urgently needs care, you can see they urgently need care, and that it's in their best interest to sedate them or manhandle them. I don't see that you need a care plan to deal with that level of decision making.
Well, the Act exists, so the Mental Capacity Act exists, which provided the legal power to enable steps to be taken. What was absent in this case was any pre-arranged system that set out how that would happen if a need for emergency care arose. And so what that led to at the relevant time was no one had given any advanced consideration to sedation, notwithstanding the fact that it had been flagged up by Mrs. Maguire some years previously and had been used when Ms. Maguire still lived at home with her family.
And you say that arrangement should have been put in place by agreement between the care home and the local NHS trust?
Precisely, my Lord.
Yes.
And can you just tell me, what would it say? Because, I mean, all sorts of emergencies might arise. What would it say if there's an emergency? Sedate Ms. Maguire, take her to hospital? Or would it specify the circumstances where that should happen?
It wouldn't specify the circumstances in which that should happen, because that would not be practical in advance, because there may be a range of different circumstances. But there's no dispute that by the evening of the 21st of February, Ms Maguire needed to go to hospital. That was the assessment, indeed, of the paramedics. That was the view of the home. So this isn't a case where that hadn't been identified. So what an advance care plan would achieve is identification that of the ways in which Ms Maguire, or indeed others in her position, could be taken to hospital. The least intrusive and most obvious way would have been by way of sedation.
But isn't that obvious anyway?
Well, it doesn't appear to have been obvious to anybody in the evening of the 21st of February.
Well, they made judgments why they weren't going to do that. But, I mean, if you need to get someone to hospital in their best interests, I mean, essentially, don't you have two options? One is sedate, the other is manhandle them.
Well,
what else would the care plan say?
One option is sedation, but it's not correct to say, my lord, that there was a judgment made or consideration given to that on the evening of the 21st of February. And part of the problem is there's no consideration whatsoever was given to that. The particular ambulance and paramedics who arrived, it didn't occur to them, and they didn't carry sedation. The out-of-hours doctor, Dr. Fairhead, when she gave evidence to the inquest, accepting as she did that her own triage in her conversation with the paramedic had been poor, said in terms of she'd elicited the relevant information, she could have sent a doctor with sedation, or there are advanced paramedics ambulances which are able to sedate. This particular ambulance was not. But no consideration was given to that by Ms Ayres.
There was nobody in the care home able to administer sedation, even if they had decided that it was in her best interests to sedate her and take her to hospital.
The care home could not administer sedation, no. That would not be within their powers or skills. Sedation would have...
So this plan that you say should have been in place could not have said the care home should be prepared to administer sedation?
No, the care home could not. The actual means by which sedation would be administered, and this could all have been mapped out in a care home, but as I say, it was never considered on the evening of the 21st of February, but the means would be a GP or an appropriate paramedic.
As I recall, one of the paramedics was not qualified to...
She was no. So the particular ambulance crew that was sent on the evening of the 21st did not have that as an option, and indeed it was not something which I think, as I recall the paramedics' evidence to the inquest, she didn't give consideration to it. Other ambulance crews could have done so an advanced one could have done.
Thank you.
So effectively, you're saying there should have been some protocol in place,
exactly,
whereby if staff were calling a GP or an ambulance to come and see this individual, they should have been warned that sedation or force would be necessary if she were to be treated against her will.
Yes, and against her will is perhaps not quite the right way of characterising it, because she was not in a position to take a capacitated decision.
Well, I appreciate that,
but my Lord's right, yes.
In practical terms, it would have been against her will.
And I suppose the answer, I mean, the objection might be, well, it's a statement of the obvious, but on the other hand, it may be that in these sorts of institutions, people follow what's written down, and what's written down then becomes important.
And it can't have been a statement of the obvious, my Lord, because people did not give express consideration to it on the 21st of February, even though it was raised by Mrs Maguire in her telephone call to the home, and even though it was something Mrs Maguire had raised previously, and even though it was known that Ms Maguire had a reluctance to attend doctors and have tests and attend hospital, such that there had been a number of missed appointments. So this was a problem that could have been anticipated. There was a ready solution, but there was no...
Sorry, are you saying that Ms Maguire should have been sedated Well, every time she had an appointment,
No.
she was booking.
No. The relevance of her having missed appointments is that it was known that she would not voluntarily attend hospital or see doctors. So it was a problem that could have been and should have been anticipated. I'm certainly not suggesting that for every appointment there should be sedation. We're talking here about a situation in which it is common ground, at least by the evening of the 21st of February, that her condition was such that she needed to go to hospital. And the only reason the paramedics that attended in the evening did not take her to hospital was because of the issue of how they would get her there.
I mean, it might be said that if an ambulance is called, that must be in anticipation of the person being taken to hospital. And if the person in question is unwilling to go to hospital voluntarily, then it's pointless calling the ambulance unless the crew are in a position to sedate the patient or are ready to take her to hospital against her will.
Absolutely, my lord. And the courts used the terms manhandle, and I understand entirely why that term is used. But it's perhaps important to put this in context. There's a duty to act in the best interest of a person who is incapacitated. And where they are, as Ms Maguire was, on a sepsis pathway and needing hospital admission, manhandling is a small price to pay. In fact, what actually happened the following morning, and the paramedic crew who attended that following morning, they didn't say it was easy and straightforward, but they were able, without significant difficulty, to extract Miss Maguire from the property by means of a carry chair. Her legs were tied to the carry chair, and they, with the assistance of two carers from the home, carried her downstairs. She was distressed, she was moving her arms around, but they were able to do it. And so this is not the case of someone who is, again, perhaps important to emphasise, albeit obvious, someone who is violent and who would have required, or indeed particularly mobile, and would have required being wrestled to the ground and fully restrained.
Going back to my Lord's question, pointless to call an ambulance if they are unable to deal with someone that may be unwilling to go to hospital. So is your complaint that the wrong ambulance was sent? I think you said that some ambulances would be equipped.
Yes, so
to do that.
It's actually very well put, if I may say so, in Mr Maguire's written case, where he looks at each of the interested parties' involvement and identifies and provides the court with references as to where things could have been done differently and which might have made a difference. And one of the options would have been if the particular paramedic, well, twofold, either a different ambulance crew is sent, so one which has the necessary equipment, training and skills, which this ambulance crew apparently did not. And there are issues about the information that was given to the NHS 111 and what was and wasn't passed on, as you'll have seen from the papers. So ambulance control, whether they had the right information given to them by others may have influenced that decision. But yes, a different more experienced crew could have been sent. Alternatively, the crew that was there, realising that there was a need to get her to hospital, but not feeling themselves confident in their ability to do so, could have radioed back to ambulance control and asked for backup or an alternative crew, including an advanced paramedic, to attend.
But they could do that anyway. I mean, I know they didn't, but if they thought that the need to get Miss Maguire to hospital was so great and they couldn't cope with it, they could have radioed for another crew.
They could have and didn't. And that may be relevant to the question of breach of the operational obligation. But more generally, what we say, and I'm answering, I think, my Lord Stephen's question in very long-winded fashion about the systemic breaches. More generally, This is a problem that could and should have been anticipated with an appropriate protocol being drawn up, so that it was known in advance that if she required to be taken to hospital because there was a significant risk to her health and she required treatment or monitoring or observations, then it was known in advance that the first line would be of approach would be sedation. The alternative would be to have sufficiently senior and assured paramedic crews who, if necessary, with backup or with assistance from the home, would physically take her out of the home.
Can I take you to paragraph 107? That's page 2669. And the regulatory framework that you're suggesting is an individual one. It's not at a high level of generality. It is tailored to the individual. But even assuming it's a high level of generality, the second sentence of paragraph 107, I don't quite follow it at the moment, is not normally to review the relevant law, that is the high level of generality and practice, but to determine whether the manner in which they were applied to the deceased gave rise to a violation of the convention. Okay. So assume for one moment that at a high level of generality, they had the authority, they had the power to sedate. The manner in which it was applied to Ms. Maguire gave rise to a violation of the convention. Does that fit in with the language of 107 or not?
It may do, my lord, and I would put it in both ways. There was the high-level framework of the Mental Capacity Act, which gave the legal power to take her to hospital, whether by way of sedation or physically carrying her. But the Mental Capacity Act is an act of broad terms. It doesn't deal with situations specifically, simply imposes an obligation to act in the best interests of the incapacitated person. So if we're still looking at it at a level of regulation, there is no regulation that compelled the production of a protocol along the lines I have described. So one could characterise that as a failure of the regulatory system. There was obviously a power to put in place such a protocol, but no obligation to do so.
But I mean, going back to Lord Reed's point that an ambulance is sent on the assumption someone may need to be taken to hospital, and if they're unwilling to go, there may be a need either to sedate or to use physical constraint. I mean, one would think that ambulance crews both generally appreciated that and received some degree of training as to how to accommodate those needs, and if they couldn't do it themselves, would have some form of instruction saying, well, call for backup for people that can do that.
The evidence doesn't suggest that that was the case, at least in relation to sedation. It was not something which had crossed Ms. Ayres, the principal paramedic of the two paramedic team who attended on the evening of the 21st of February.
Right, but I'm just looking at going up to a higher level of abstraction. Wouldn't that be what one would expect ambulance crews to do generally? I appreciate that there were failings here, but I'm just trying to understand exactly what you're saying should have been done in terms of regulation, which wasn't.
Well, what we're saying in general terms is that there should have been, and this would apply not just to Ms. Maguire but to others, there should have been a protocol or plan prepared in advance which would have recorded the need for particular steps to be taken in the event of that individual having to go to hospital. And this must be a common enough occurrence in terms of a broader need to have such arrangements in place. Sorry, my lady.
No, you finish it.
And that would have meant that on that day, when the paramedics attended, if it was the junior paramedic crew as we know it was, they would have had something which alerted them to the fact that this was sedation in the first instance was the option to pursue, something which never crossed their minds, it would appear. and which they didn't themselves have the wherewithal to do. And then the necessary arrangements could have been made, and those could have been made very quickly. That's the evidence of Dr. Fairhead, the out-of-hours doctor, is that arrangements could have been made if anyone had thought about it. But that's the problem. No one thought about it in advance.
But yeah, there's a slight difference between what you said on occasions. You said there should have been a protocol prepared in advance which would have recorded the need for steps to be taken. But then you said there's no regulation that compels the production of a protocol in advance. Now, is the systemic failure that you're relying on a failure of the regulatory framework to require homes, such as this home, to have that in place? Or do you say that the fact that there's a power to have that in place means that there's a regulatory failure if a particular care home does not have it in place? And I'm assuming that if there had been a protocol of the kind you describe in place in this evening, but everyone had just forgotten about it or ignored it, there couldn't have been a regulatory breach or a suspected regulatory breach. So there's sort of various steps that you need to take, but which is it that you say is the breach of this regulatory framework obligation?
Both, my lady. So viewed, it depends at which my lady's absolutely right. There are different levels of generality and abstraction. One starts with the existence of the very high-level abstract regulatory framework, which is the Mental Capacity Act itself, which confers the power but gives no further concrete guidance. And so there is a failure in two different respects, the two identified by my lady, both which we say are capable of being characterised as falling within this idea of systemic or regulatory obligations. There is nothing in the actual regulations themselves.
I'm sorry, you were talking about the Mental Capacity Act, so are you saying that the Act is defective?
No.
Right,
No,
okay, I'm sorry.
Forgive, I'm not making myself sufficiently clear. So the Act is the Act, and I'm not suggesting that only in an Act of Parliament can there be appropriate guidance or regulation. There are a number of different ways in which you can have a regulatory framework, and it can be by way of guidance, it can be by way of statutory regulations, it can be by way of policies. Regulatory framework is a broad concept. It's not talking simply about legal regulation. And so there is both a failure for there to be anything in the regulatory framework understood in that sense.
Sorry, in a legal sense, so not the Act, but in legal regulations.
Well,
is that
not
what you're
necessarily,
saying?
it wouldn't have to be legal regulations. It could be legal regulations, but it wouldn't have to be. It could be by way of guidance. It could be by way of policy.
Saying all care homes, if you have someone who doesn't have capacity, you must have in place some instructions to the people taking care of this incapacitous person to say that if they need to go to hospital and they're refusing, they can be sedated or should be sedated or something along those lines.
Yes, at least if there is reason to think that that's something that might arise in relation to the individual. There may be individuals for whom that is completely implausible that would ever arise. But for Ms Maguire, and no doubt for a significant number of people in care homes and similar placements, it will be an issue. So there's that level, and then there is the second way in which my lady...
Well, I'm so sorry, before we move on to the next level, I just want some sort of precision about what it is you're saying. Are you saying that there should be some sort of regulatory instruction to care homes to have some sort of protocol in place for all inmates on an individual basis, so an individual care plan, what to do if they need to be taken to hospital?
Yes.
Right.
Can I ask you a couple of questions? It does strike me this is a slightly unusual case in that if you like, the question that the question we're having to answer is one which will have implications for inquests in the future, where the sort of questions you're being asked to answer at the moment would be questions answered at the end of the investigation rather than at the outset, once the evidence was out. But in the present case, of course, the evidence was led. And I wonder if I could ask you a couple of questions about it. First of all, did the care home staff, did the care home have the authority to authorise Miss Maguire's sedation?
No.
So who would have had that authority?
Any doctor or appropriately trained healthcare professional, such as a paramedic. So at an appropriate level, with the right training. There are paramedics who can sedate, a fact of which the individual paramedic crew on the ground appears to be unaware, or doctors can sedate.
I see.
And I'm sorry.
But I mean, there must be issues all the time that arise if somebody needs to go, if a resident of the home needs to go to the dentist, for example, and they need to get an injection, or to have a filling done. Somebody must have the power to authorise these things.
Well, a decision's then taken in the best interest of the individual by reference to the circumstances which prevail. So it's a question of balancing the need for the intervention against sedation.
Who has the authority to take the decision?
It can be there can be a collective view that something needs to be done, but then the actual sedation.
It's a question of law. There must be somebody who has guardianship powers, if that's the right way of describing them, over a person who isn't mentally capax.
So there's no one who has guardianship powers. The position under the Act is that all those who have a role in relation to care and treatment can effectively be best interest decision makers. But obviously a care home trainee is not going to take a decision about surgery. So it depends upon the nature of the treatment in question. Here we're talking about, in a sense, collective failures, because what should have been anticipated was that this situation might arise, and therefore at a level of the local authority, the provider, and this is a provider that provides a number of care homes, but the local authority placing her there, funding her care, authorising her deprivation of liberty, this is something that could and should have been anticipated and addressed by means of an appropriate protocol, identifying that this was the ideal, the preferred route to get her to hospital when the need arose. As and when the situation actually arose, someone who is qualified to administer sedation, and that would be a doctor or some paramedics, I mean, there'll be others as well in hospitals and so on, but for present purposes, doctor or paramedics, would obviously have to take the decision that they thought that was the appropriate treatment to give at that particular moment in time. And that's then a decision for the person administering the sedation. Well, but we're talking about the logically prior step.
It'd be helpful to me if you could give us, not now, but at some point, a reference to the legislation that governs this. I mean, for example, if it were a child, the parent would be the person who had the authority. I mean, obviously, the parent isn't qualified to administer the sedative, but if it's being given by injection anyway, but the parent would have the legal power to authorise medical treatment. And it'd be useful to know what the statutory provision is in relation to people in the position of Miss Maguire.
Yes, it's at a very high level of abstraction. In relation to Ms Maguire, when she was in the care of her mother, Mrs Maguire, and the need for her to attend for hospital interventions had arisen previously, it was arranged as between Mrs Maguire and I think it was a nurse, but I'll check that.
Well, I'm really more interested in legal powers than in what happened in practice. We have to decide according to the law.
Yes.
The other matter I want to ask you about is we've been focusing on the care home end of things. One might think that it's a not altogether uncommon experience for ambulance crews to be faced with individuals who are supposed to be taken to hospital but are unwilling to go. And one might think that crews are given training or instruction about how to deal with situations of this kind. I don't know, was that explored in the evidence?
It was. There was some guidance, but which was at a fairly, again, general level of abstraction about the ability to best interest decision making and the ability to use force where someone lacks capacity. I will find the reference for my lords in due course.
I mean, for example, it was suggested to you that one would think that if somebody was meant to be going to hospital and unwilling to go, but the particular crew couldn't administer a sedative, then they would alert their headquarters so that a better qualified crew could be sent out to administer the sedative. But we don't know I don't know if there is any such procedure in place or not.
I think that the short answer, my lord, is that there wasn't any such a policy or guidance specifically in place in relation to that. The policy on use of physical intervention and restraint, let me just check that, this particular ambulance services policy is at 1269.
I mean, I'm asking about this simply because if there was what Strasbourg would describe as a regulatory failure, it might be at the care home end, or it might be at the ambulance service end. So that, I mean, ultimately, the reason this lady died is because the ambulance crew didn't take her to hospital, it seems.
So the only guidance from the ambulance service is at it starts at page 1245. Before we look at that, just in relation specifically to the evidence given by the paramedic at the inquest, there was a factual dispute as to whether, the evidence of Ms. Ayres, the senior paramedic, says there was no discussion about sedation, and she said it was only afterwards that she learnt that sedation is something that advanced paramedics can do, and the reference to that is page 1661. I'm afraid I don't have the references to precisely where on the page that is. So there was an arguable failure there. In relation to
can ambulance crews restrain someone?
Yes.
So even if they couldn't sedate her, they could have restrained?
Yes. Which is exactly what they did the following morning.
Yes.
Ms. Richards, could I just ask you this before we depart from paragraph 107 of the judgment to which you took us, and the question my Lord Stevens raised in relation to the second sentence. You're addressing us at the moment about the framework obligation. I have difficulty in... It seems to me that the second sentence indicating that we must have regard not to relevant law and practice in abstracto, but determining the manner in which they were applied. Doesn't this lead us into the operational obligation? And how do we distinguish between the two?
Well, it is frankly it's a very good question, my Lord. It's a recognition of what courts have from time to time said, that it's not really always easy to distinguish what is the systemic or general obligation and what is the operational obligation. There isn't necessarily a bright line between the two. And everything that I've talked about so far is capable of being something that falls under the operational obligation as well.
Right. Thank you very much.
So you're relying on breach of both obligations?
Yes, absolutely.
Thank you.
Right, and so just going back to my point about the two levels, you are saying that there should have been a regulation requiring the care home to have a protocol, as you've described it, in place, and also, even if there hadn't been a regulation requiring that, they should have had a protocol in place.
Yes.
Particularly in the context that the person was detained, vulnerable, and under the care of the state.
That's precisely the point. Yes.
Well,
But not every patient.
well, wait a minute. I thought we'd got to the point that this regulatory framework is not dependent on regulatory framework.
My understanding of the argument was that that degree of specific attention is called for in relation to people of this particular category, that is detained, vulnerable.
Yes. So if I can put it this way, if I just square the circle, the systemic obligation is an obligation that in principle applies to everybody. So there's no dispute, as there is in relation to the operational obligation, that it only applies to certain cohorts or classes of individual. So in the healthcare context, it applies to all who might require healthcare at a general level. But when one then looks to see what actually might need to have been the measures in place, there may be different measures for different cohorts of people. So the system of regulation or policy or guidance that might be required in relation to psychiatric patients may be different from what may be required in relation to those at risk of the criminal acts of third parties, which will require there to be policies, measures, regulatory framework in relation to what the police do. So the systemic obligation is of general application, but when one actually tries to look and see what's the arguable breach in an individual case, then one has to look at the more specific situation of the cohorts that one is concerned with.
But what's the relevance of her being voluntarily detained at this point? I mean, if she lacked capacity, but was living in the... If she lacked capacity as regards her choice as to whether to go to hospital or not, but didn't sufficiently lack capacity to have to be detained, wouldn't this protocol still be needed?
It might do, it might be. So it's not a case which, it's not an argument which rests solely on the fact of deprivation of liberty. Deprivation of liberty is one of those interlinked circumstances in terms of somebody in the care of the state, under the control of the state, deprived of the liberty by the state, and vulnerable. Obviously, you will also have people living in care homes, for example, who have capacity, who are there because they are perhaps frail and elderly and have physical care needs, but entirely competent to take decisions about whether to go to hospital or not. And you would not need, nor would you be empowered to have any such protocol in place for those who have capacity, because you cannot sedate or restrain or compel to go to hospital someone who has the capacity to say, I don't want to.
I'm still trying to get clear in my mind exactly what this protocol would say, because I would have thought that a decision to sedate or not must be for the medical practitioner, be it paramedic or GP, who has to administer that. It's not a light thing to sedate someone. It requires a medical judgment at the time. So I'm not sure that the protocol could say you must sedate.
No.
Because that would obviate the exercise of professional judgment. So is the protocol just consider sedating? Is that what you're saying it should have said?
Essentially, my lord, yes. The protocol would say, in relation to the protocol or care plan for this patient, would say this is a patient who may well have a need to go to hospital. She has a range of physical health problems. She's of a certain age and so on. We know she has a history of refusing to go to hospital or refusing to see doctors. She lacks capacity. She's not going to be able to agree. She will probably resist or show distress. And therefore, when she needs to go to hospital, there are two ways of getting her there, or three ways. Persuasion, if that doesn't work, sedation, if that doesn't work, physically taking her. I absolutely accept, my lord, that on the ground on the day, the out-of-hours GP or the paramedics got to, as part of their professional obligations, be satisfied that that's the right thing to do. The problem here is that that was simply not considered on the 21st of February by anybody. It was not considered by the out-of-hours GP, and it was not considered by the paramedics. And had there been such a care plan or protocol in place, of course care plans can be ignored, but it ought to have alerted them to this is what would need to be done.
I mean, I can see that a care plan can be a prompt to that sort of thing, but wouldn't it be a matter for the exercise of their judgment anyway? If you're faced with someone who it is thought should be taken to hospital, they're unwilling to go, I mean, we've already discussed, you can either sedate or use physical restraint in those circumstances if you think the need is great enough. Isn't that obvious anyway? That I appreciate that you can criticise them for not thinking about it, and I could see that if what you're describing as a protocol had been there as a prompt, that might have made them think about it. But shouldn't they be thinking about it anyway, as these are the obvious options that they should have been thinking about?
My lord, that may well be the case. We know they didn't. It's a reminder, perhaps, that setting out in advance plans, even where you might think that they're quite obvious plans, is highly important when you're dealing with the care of vulnerable individuals.
Right, but I mean, might it not be said if they should have been thinking about these things anyway, that has some tendency to detract from the need to have a protocol in place?
No, my lord, because we all know that things don't always happen as they should, and people don't always give consideration to the things that they should, particularly, no doubt, people who might often be providing care or assistance under time pressures or constraints. And so this kind of advanced protocol is exactly the kind of measure that would have meant that conscious consideration would have to have been given to this. And I would go further to say the likelihood is that would then have been done because Dr. Fairhead, the out-of-hours GP, who admitted to the inquest that her triage was inadequate, that she didn't ask the right questions of the paramedic. She said if she had asked the right questions and understood, as she and the paramedic apparently didn't, that there had been a very recent fit, they seem to think it was there'd only been one fit 5 hours previously, she'd have sent what she called a visiting GP with sedatives. But all I have to do in any event in relation to this is map out an arguable breach or credible suggestion of breach, because as my Lord Lloyd-Jones or Lord Lloyd-Reid pointed out, that this court is not required to make any findings of breach of Article 2. The question is whether there was, assuming the duties to exist, and in the systemic case we know that they do exist, that there's a credible suggestion of breach such that the matter should have been left to the jury to make a determination. And it would then have been for the jury to consider precisely the kind of matters that my Lord is exploring with me. It was, I think, some time ago that my Lord had asked me to map out systemic breaches. Might I come back to that, my Lord?
Certainly.
Because there are 2 or 3 other examples that we would give. But if I get to that once I've got through the case law, it might be assistance. I had given my lady the reference to the North West Ambulance Service policy. There's no particular place I want to take you to in it. It starts on page 1245. It gets to physical intervention on page 1269. And obviously, if there's any matter that I need to deal with specifically in relation to that, I can come back to it. My lords, my lady, the last case, just to try and flesh out some of the approaches to systemic breach in the case law, the last case I wanted to go to for present purposes is the case of Trust Canova, page 5524. So the judgment starts on, forgive me, judgment starts on page 5506. And the factual context of the case, you can see simply from paragraph 1 of the judgment on page 5508, the death of the applicant's daughter while she was participating in a clinical trial of a new medicine. And then if the court goes to page 5524...
Sorry, page again, please.
5524, Lord. You'll simply see in paragraph 80, and in the interest of time, I'm not taking you through all the preceding paragraphs which the court may wish to read, but you'll see, and this is in relation to systemic breach, the systemic duty, the finding in paragraph 80, bearing in mind the above shortcomings, so that was shortcomings in relation to the clinical trial process, her vulnerability and the serious consequences of those decisions for her, the court finds that the practical implementation of the existing framework was deficient and that the existing guarantees ensuring the informed consent of participants of clinical trials were not complied with in the present case, and thus the breach of Article 2. And again, I draw attention to that simply because it makes clear that the systemic breach is not simply concerned with the existence of a regulatory framework, but also with how it is implemented in practice. My Lords, my Lady, can I then turn to the operational obligation?
Obviously, we're being taken to decisions we've never seen before.
I'm sorry.
We look at one sentence out of a decision that may be quite long. Potentially, this looks quite important. Is the important to what we understand by this systemic deficiency? When the court finds that the practical implementation of the existing framework was deficient, is that a finding that it was generally deficient or deficient in the case of this particular patient, particular individual?
The latter, as I read the judgment. If I take my Lords and my Lady back...
And similarly, where it continues that existing guarantees were not complied with in the present case, I mean, that's another individual shortcoming, is it?
Yes.
So is there a finding then of a breach of the systemic obligation in respect of a breach of a systemic obligation based on lapses in one individual case?
Well, my Lord, I was taking it too quickly. My Lord's quite right. To understand paragraph 80, it's important to go back and see what's said earlier in the judgment. And I think we can pick it up at paragraph 75 onwards, which is page 5522, bottom of the page. And so you will see there's the general finding that the regulatory framework itself wasn't an issue. The safeguards and procedures to be followed when organising and carrying out a clinical trial were established in a relevant legal measure, and their practical implementation was established in a relevant bylaw. The court does not discern any deficiencies in this respect that could entail a violation of the state's positive obligations. And then paragraph 76, the practical implementation of that legal framework in the present case is, however, open to doubt.
Isn't there the court shifting to the operational duty?
Yeah, looks like it.
Well, my Lord, I don't think it is, because this is a recent judgment of the court. It post-dates Lopez de Sousa Fernandez and the approach to be taken in relation to healthcare more generally.
Quite, but that authority, as you showed us, laid out the distinction between the framework duty and the operational duty. I'm not picking up a sort of headings which divide the two in this judgment. the judgment doesn't seem to go. Sorry, are you going to tell me? I haven't read it before now, but are you going to tell me it does?
Well, not with the identical headings that we saw in the other cases, but if my lord goes to page 5521.
That's talking generally about application of the principles. Have they set out?
Well, what
they've referred to Lopez de Sousa.
Yes, so they refer to Lopez de Sousa in paragraph 69. So they say the court reiterates that in the context of healthcare, the state's substantive positive obligations relating to medical treatment are limited to a duty to regulate, and then that's articulated. And then the next sentence, the courts emphasise the state's obligation to regulate must be understood in a broader sense, which includes the duty to ensure the effective functioning of that regulatory framework. So this is all the systemic duty. The regulatory duties thus encompass necessary measures to ensure implementation, including supervision and enforcement. That's paragraph 189 of Lopez de Sousa Fernandez, which I took the court to. And then paragraph 70, important to have access to information enabling people to assess those risks. It's held in particular the states are bound to adopt the necessary regulatory measures to ensure that doctors consider the foreseeable impact of a planned medical procedure on their patient's physical integrity and to inform patients of these consequences beforehand in such a way that the latter are able to give informed consent. So this is, I entirely understand why my lord poses the question as to whether this is concerned with the operational obligation, but it articulates none of the principles or case law relating to the operational obligation and is concerned, as I suggest this judgment should be read, with the systemic obligation.
And it's treating also the, it's not attaching any particular importance, seemingly, to the fact that the daughter was, suffered from mental illness. I mean, it's treated as a straightforward application of Lopez de Sousa.
Yes. The illness, I think, or the daughter's own individual situation is regarded as relevant, not in terms of changing the nature of the duty, but just in terms of the kind of risks that she would need to be informed of. And we can see that in paragraph 77 and 78. But in paragraph 76, having found that the regulatory framework itself was effectively impeccable, or couldn't be called into question from an Article 2 perspective, paragraph 76 then goes on to talk about its practical implementation in the present case. And then you'll see there were protocols in place, but it doesn't appear that they were adhered to in the applicant's daughter's case. This is halfway down paragraph 76. And then references to lack of information regarding monitoring of her state of health. She then displayed symptoms, but was invited to participate in the second trial. And they say that I think that was unacceptable. That's the second sentence, the last sentence of paragraph 77. And then they look at the issues relating to the consent-taking process in paragraph 78. And there are deficiencies in terms of information, the second half of paragraph 78. So the health professionals in charge of the clinical trials unaware of her actual state of health, and therefore she didn't receive full information to make an informed choice. So those are the factual findings which lead then to the conclusion in paragraph 80 over the page. A clear indication in my respectful submission that the systemic duty is not simply to be seen at the high level of abstract generality. And there's no reference here to any of the formulations of the operational duty. There's no reference to the case law, but no reference either to the concept of real and immediate risk, the Osman, Keenan, etc. formulation.
Yes, I was just looking back at Lopez de Sousa. I mean, I think you're right that the paragraphs cited in paragraph 71 are concerned with the systemic duty. Sorry, in paragraph, you did show it to us.
189 of Lopez de Sousa.
Yeah, and 186.
And it was the whole significance.
69, yeah.
And the whole significance of Lopez de Sousa Fernandez is effectively it's saying there is no operational obligation in the vast majority of healthcare cases. There's obviously a hugely important carve-out of that in paragraph 163, which I'll come on to shortly. So if I turn to the operational obligation, and this is where really the key issue of legal principle is whether there was an operational obligation owed in cases of this kind, in this kind of context.
Sorry, why do you say that's the key legal issue? I thought you rely on breach of both.
Oh, I am, my lord. But there's no dispute or doubt that the systemic obligation in principle applies because it applies across the board.
Right, but you've shown us a case where the breach of the systemic obligation seems to extend down into application of the system on the particular facts.
Absolutely.
I would have thought that is disputed.
That may well be disputed, my lord. You're right.
Okay, all right. Sorry, just.
I'm sorry. That there is a systemic obligation at a high level is not in dispute. What is in dispute, and what was rejected by the courts below, is that the operational obligation identified in the chain of case law from Osman applies in this context. And so that's what I want to turn to now by looking at the case law. We've sought to trace the...
This Trans-Canova case does that post-date the Court of Appeal's judgment?
It probably does, but it's a very recent decision.
Yes, I think it was in August this year.
Yes, so it does. So we've sought to trace the evolution of the operational obligation in our written case. And I'm not going to go through all the older authorities. It's from paragraph 28 of our written case onwards. You will see that we've referenced a 1998 case called LCB in the UK. I don't propose to take the court to that. It's at page 5037 of the bundle. And then the operational obligation, as it's now known, is articulated in its, for the first time explicitly in the case of Osman in the UK in 2000. Again, I don't propose, unless the court would be assisted by it, I don't propose taking you to Osman. It's at page 2930 of the bundle. But it was in that case, which concerned risks to the life of an individual from the criminal acts of a third party, that it was said a duty to take reasonable protective measures would arise where there was a real and immediate risk to life. So that's the Osman formulation. So the origin of this operational obligation is protection against criminal acts of third parties. The next significant development is the case of Keenan and the UK, 2001, where the Osman formulation is applied in the context of prisoners. And I will ask the court to turn to that briefly. It's page 4835. The court looks at paragraphs 89 and 90. So 89 starts on page 4834. And picks up on what had been said in Osman. Osman itself is referred to in the last sentence of paragraph 88. And so the duty is there described. And then paragraph 90 on page 4835, in the context of prisoners, the court has had previous occasion to emphasise that persons in custody are in a vulnerable position and that the authorities are under a duty to protect them. And then various matters and arguments set out. And then paragraph 92, in light of the above, the court has examined whether the authorities knew or ought to have known that Mark Keenan posed a real and immediate risk of suicide and if so, whether they did all that reasonably could have been expected of them to prevent that risk, on the fact the case did not succeed. But that was the next development in the evolution of the operational obligation, so applied in the context of prisoners found to be in a vulnerable position with a duty of protection, and to a risk not from third parties but suicide.
So one needs both. One needs detention and also they knew or ought to have known of a risk. Yeah. Yes.
And until we get to more recent case law, the knew or ought to have known has conventionally always been part of the operational obligation. The next authority then, which I think may assist to go to, is the case of Edwards in the UK, another prison case, page 4608. The judgment starts on page 4608, and the court will see it was a case in which a prisoner was died after being attacked by a fellow prisoner. And if the court picks it up, it can probably be done from the head note, page 4609, paragraphs D through to G, you will see that what the court examined there were a range of what could be described as healthcare shortcomings. So there was the inadequacy of assessment of the cellmate's risk, the failure to provide information about the cellmate's medical history to the prison authorities, and then the health screening that was undertaken. So these are paragraphs E, F and G. The health screening that was undertaken on arrival at the prison. And then if the court goes in the judgment to page 463, well, if we pick it up on page 4628, so we'll see the reference in paragraph 56 on page 4628 to the vulnerability of those who are in custody and the duty of authorities to protect them. That's the first sentence of paragraph 56. And then paragraph 57, under the heading Application in the Present Case, halfway down that paragraph, you'll see the court has examined firstly whether the authorities knew or ought to have known of the existence of a real and immediate risk to the life of Christopher Edwards from the acts of Richard Linford, and secondly, whether they failed to take measures within the scope of their powers which judged reasonably might have been expected to avoid that risk. So that's the Osman or operational duty formulation. And then you will see, if you go over to the next page, there is then consideration of what was known about Richard Linford. Halfway down the first paragraph on page 4629, there are criticisms of the assessment undertaken by the psychiatric registrar. And there are then, from paragraphs 60 to 61, criticisms of the information about risk that was or was not shared amongst those who were involved in caring for the prisoners. And I won't read through the rest of the paragraphs, but the conclusion on paragraph 64, page 4630, is that the failure of the agencies involved in this case, medical profession, police, prosecution and court, to pass on information about Richard Linford to the prison authorities, and the inadequate nature of the screening process on Richard Linford's arrival in prison disclose a breach of the state's obligation to protect the life of Christopher Edwards. So an operational breach there found in the case of a vulnerable prisoner in custody. The court, the Strasbourg court, I should have said I'm starting with the Strasbourg authorities and will then come to the two leading or most relevant domestic authorities.
Can I just ask, the breach there, which you've described as operational, seems to sort of overlap with the implementation of the system breach that you took us to in the Trascanova case, because it seems like that there were screening systems in place. It's just that they weren't operated in the proper way. Can you help us about the interaction between those two things, or do you say they just overlap?
My Lord, I say they just overlap, and that was recognised by the Court of Appeal in the Humberston case, which was the Yorkshire Ambulance Service case, which I took my Lords to a while ago. And that was paragraph 62 of the judgment in Humberston, page 2075.
Obviously, you're taking us to these cases at the moment as authorities on the operational duty.
I am.
Is Trascanova is it an outlier in conceptualising what might be thought of as operational breaches as failures to implement effectively regulatory a proper system?
I wouldn't characterise it, my Lord, as an outlier. It is an example of a case where a breach has been found on the basis of deficient implementation. But the reference, the more principled reference to looking at the implementation of the framework and considering matters of enforcement and supervision it is set out very clearly in the judgment of the Grand Chamber in Lopez de Sousa Fernandez.
There's always been a bit of an overlap in that even with the systemic obligation case, the claimant has to show that that deficiency had some causative effect on the death of which they're complaining. So one has to descend from the abstract consideration of the regulatory framework to the extent of showing that actually it made a difference in this case, or arguably made a difference in this case. And that was what I was looking at Trascanova and saying, well, perhaps, thinking to myself, well, perhaps that's actually all that they are doing. But you say, and it does seem that it sort of mixes up, really, the systemic obligation and the operational obligation.
Yes, I mean, I would simply characterise it as an overlap.
I mean, in the first sort of case, and on my understanding of paragraph 107 of the Lopez case, that seems to be saying if you identify a systemic breach, there's an additional thing that you have to show before you can show breach of the substantive obligation in Article 2, namely that breach in the systemic system has fed through to the actual treatment received by the individual. But Trascanova seemed to be a different sort of case where it said there's a full satisfactory regulatory regime at the relevant level of abstraction, but that there's been a problem in the implementation of that, what is in principle a satisfactory regime in the individual case. So those two seem, well, at first blush, to be quite different sorts of case, which is why I was asking you about how the second Trascanova sort of situation meshed with the operation breach of the operational duty. But at all events, as I understand it, you're just saying that they overlap, that there isn't a clear divide between them.
Yes, there's no bright line between the two.
But Trascanova does seem to be going a step further than the Lopez case then. Would you accept that?
I wouldn't characterise it in that way, my Lord. I would say it is an application of the principles articulated in Lopez at paragraphs 186 and 189, where you look at supervision and enforcement as part of the delivery of the regulatory system. All that's different, arguably, about Trascanova is that they're looking at it in an individual case. It might be said that realistically is the only way in which the Strasbourg Court probably can look at it, because it's being asked to consider an individual case.
Well, I mean, in the Lopez case, it's looking at an individual case. Strasbourg always looks at the individual case.
But in Lopez de Sousa Fernandez, they don't go on to consider, in terms of application of the principles to the facts of the case, that particular bit about enforcement and supervision wasn't really directly in play so much in Lopez de Sousa Fernandez in the way it is in Truscanova.
And what's the break on the Truscanova case in relation when you apply it to every single aspect of medical treatment in a hospital? If there has been a failure to apply a regulation to any individual patient, then there would be a breach of Article 2. You can have regulations about how you perform operations or when you have CAT scans. So.
Well, obviously, there needs to be, as my lady mapped out, the causal link between that and death. I
mean, in a sense, you're almost very likely to have a causal link. If someone has died on the operating table or something like that, one might think that it could always be potentially argued that it's because of a failure to implement standing instructions or something like that. And as you say, that's all you need. That seems to cast the net very broad.
Yes, I should say it's no part of my case to try and map out a duty applicable to all hospital patients. Indeed, in relation to Ms. Maguire, for the present purposes, she didn't become a hospital patient until it was...
no, but we're exploring the implications of the arguments you are making.
I understand that, my lord. It may... The courts, the Strasbourg court, has drawn distinctions between what they call an isolated error of judgment and then which doesn't fall within the systemic obligation. It can if the operational obligation applies. Obviously, it gives rise to a breach of the operational obligation. But an isolated error of judgment on the part of a healthcare professional, as against something more systemic in nature. One interpretation of Truscanova is that they're identifying a series of system failures.
But we know from experience that these sad cases are not usually the result of just one thing going wrong, are they? They're the result of a whole series of missed opportunities, wrong assessments, failures of communication. That's what always comes out of any kind of investigation. So it does raise a very difficult question as to, as my Lord Stevens says, how do you stop the overlap that you identify between Truscanova and the operational system from expanding the state's obligations really quite far beyond what the court seemed to have been saying in the two Portuguese cases.
Yes, well, I think, and in particular the Lopez de Sousa Fernandez case, Fernandez de Oliveira involved both the systemic and operational obligation. My Lord, I don't think I can give a complete answer to my Lord's question other than to say that one could characterise Truscanova as identifying serious failures to adhere to the system and distinguishing it in that sense from what has been termed by the Strasbourg Court in other cases isolated errors of clinical judgment or isolated medical...
My only problem was that I thought that every medical negligence case could be categorised as the failure of practical implementation of a regulation. And so, well, I mean, I just had difficulties with it.
Perhaps not every case, but I accept that there will be a number of cases that could be characterised in that way. Apparently, my lady, those at the back are having difficulty hearing my lady. I don't know whether there's a microphone deficiency. Any of them. So returning, if I may, to the operational duty.
When we adjourn, we'll have the microphones checked. I'm not sure if they're all working.
My Lord, is certainly now audible in a way that you weren't.
I'm not sure Lady Rose's one is.
The cases I'd identified so far in relation to the operational duty, Osman, Keenan and Edwards, were all cases either where there was a risk from the acts of a third party or where there was a risk of suicide.
I'm sorry, I didn't hear that.
Or where there was a risk of suicide.
Yes.
The European Court then began to consider the operational duty and apply it in cases where the risk was not of suicide or homicide, but where it arose out of deficiencies in the medical treatment provided to those who were detained, or the facilities available for the treatment of those who were detained. And a paradigm example of that is the case of Tararayeva and Russia, page 3022. And so if I can take the facts from the head note on page 3022, the court will see this was a case of a prisoner with physical health problems, diagnosed with an ulcer, prescribed medicines, and his treatment was at some stages within the prison medical facilities, or the colony as it was described, and at some stages within the public hospital. Surgery undertaken and so on. And then the second paragraph of the head note explains how, after undergoing further surgery at the prison hospital, he died. Case was brought on Article 2, and if the court turns to the court's assessment starts on page 3037. You'll see the general articulation of principles, paragraph 73, 74 to 75. But if we pick it up with the application of principles in the present case, what you will see in paragraph 76, although it doesn't precisely echo the formulation in Osman and Keenan, is something which is, for practical purposes, the same or similar. So there's reference to Mr. Tarayeva, this is paragraph 76, in custody, accordingly under the control of the Russian authorities. It's not disputed that he suffered from various chronic illnesses. The government did not deny that the authorities had been well aware of those ailments, which had required constant medical supervision and appropriate treatment. In these circumstances, the court considers the authorities should have kept an ongoing record of Mr. Tarayev's state of health and the treatment he underwent while in detention. And then there is a detailed examination of the care provided to him. I don't propose to read through it, but it is a judgment that needs to be read in full. So under the various headings, there's a discussion of the adequacy of medical care at the colony, so those are the prison facilities, paragraph 77 through to paragraph 80. And perhaps if we just pick up, so there's a number of criticisms of the care, and then paragraph 80, we perhaps pick it up about 7 or 8 lines down in paragraph 80, lacking current and reliable information on his state and health, as is originated from the record, had either been left behind at the detention centre or mislaid at the colony. The colony authorities did not arrange for his examination by a specialist, etc. And then there's a reference to an obligation to ensure appropriate follow-up care. And then the conclusion, the last sentence of paragraph 80, is that he was not adequately examined, did not receive medical care appropriate to his state of health. And then over the page, paragraphs 81 to 85 appear under the heading Adequacy of Medical Care at the Hospital. This is the public hospital. Again, I don't propose to read through the detail of it, but you'll see, for example, in particular, paragraph 83, the last two sentences refers to the hospital doctors providing colleagues in the prison hospital with an incomplete medical record and reference to crucial information missing. And paragraph 84, last sentence, medical care administered at the hospital was inadequate, is the court's finding. And then over the page, under the heading adequacy of medical care at the prison hospital, this is page 3041, paragraphs 86 to 87, there are then further criticisms of the care and facilities, and the concluding sentence of paragraph 87, in light of these facts, the court finds that the prison hospital was not sufficiently equipped for dispensing adequate medical care and that there was a causal link between these deficiencies and the death. And then the summary, paragraph 88, courts made the following findings in respect of the applicant's contention that the Russian authorities failed in their duty to protect Mr. Tarayev's right to life. And then the summary is there set out. Problems with the medical records, problems in terms of examination, defects in surgery, and then over the page, paragraph 89, the court finds there's therefore been a violation of Article 2 of the Convention on account of the Russian authorities failure to protect Mr. Tarayev's right to life.
And what gave rise to the operational duty? In the sense of the earlier case of Osman, there has to be a real and immediate risk to life. Was that a part of the reasoning of the court in this case?
Not in any explicit sense, no, which is why Tarayev appears to be, as it were, a refinement or development of the operational obligation, and why we've said in our written case that there appear to be two routes to establishing breach of the operational obligation. There's the real and immediate risk route, and then there's the failure of adequate care for detainees route. But,
is this an operational breach of operational duty case? So, I mean, the last bit of paragraph 87 rather suggested that, to me, that it was a breach of systemic duty case where it could be established that there was a causal link between the systemic deficiencies and the death. Have I misunderstood?
Well, I'm not sure I can give my lord an absolute black and white answer, because the court doesn't expressly analyse it either in terms of the systemic duty or in terms of the operational duty. Although in later case law, Raybone may look at it in that light, it seems to be viewed as a breach of the operational duty. Paragraph 76 on page 3038.
Oh, so sorry, you're saying this case is you would analyse it as breach of the operational duty?
I would.
Right. Thank you.
But I acknowledge a degree of ambiguity, but that is how we would analyse it. And we would suggest that paragraph 76, although not framed precisely in terms of the Osman-type formulation, essentially is touching on the need for there to be knowledge of the risk to life.
In the context of Article 2, is the obligation to protect,
Yes.
does it extend further than protect against a risk to life?
Well, the obligation to protect also extends, arises under Article 3 of the Convention. And there are in the bundle, and we've referred to some of them in our written case, a number of Article 3 cases where a similar approach is taken. The need where you are you have people in your custody, as it were, to provide them with adequate medical treatment. And if they survive, it can be a breach of Article 3 when you don't. And if they die, it can be a breach of Article 2.
What about Article 8? I mean, there are some cases that talk about right to respect for private life as comprehending physical integrity and so on. Are there cases that also say there's an obligation to protect in relation to Article 8?
I'll have to come back to my Lord in relation to that. My Lord's absolutely right that Article 8 is so broad. It certainly has been held to encompass physical and psychological integrity. And so failures to provide treatment can give rise to breaches of Article 8. We don't, I think, have any particular examples in the bundle. I may need to revert to my Lord on that.
But going back to this real and immediate risk, of course, given that it's an Article 2 case, the person has died. But do you accept that one must be careful not to look at it with the benefit of hindsight and assess what the risk was at the time of the events, even though we know that the person did in fact die, so there was in fact an immediate risk of death, which in fact eventuated, but one has to be careful not to make a jump to say, well, this was obviously an Osman case.
In terms of assessing breach, that is no doubt something which, if one were holding an inquest and a coroner giving directions to a jury who were being asked to return a judgmental conclusion, as they would be asked to do in an Article 2 compliant inquest, no doubt those are the kind of that's the kind of advice and guidance that one would expect the coroner to give. Of course, in relation to the conventional formulation of the operational obligation, it's knew or ought to have known. That's obviously not bringing in hindsight, but it's looking at what was available or ought to have been available or ought to have been appreciated by those whose acts or omissions are being called into question. But again, that's the outcome, that's the finding of breach, which is what we say we never got to because of the coroner's erroneous approach. This, obviously, a prisoner case, as had been Keenan and Edwards, but in Slimani and France, the European Court took a similar approach to someone held in administrative immigration detention. I don't propose to take the court to it. It doesn't greatly illuminate our understanding of the underlying principles. It just shows another context in terms of detention. We've set out in our written case at paragraph 32 the extract from the judgment in Slimani, which is paragraph 24 of the judgment, but the court's reference, it's page 5452 of the bundle, and there factors again of vulnerability and control are the factors that are identified. The next iteration of the operational obligation, if I can put it that way, in the Strasbourg case law, it concerned conscripts, military conscripts. And so if the court would turn to the case of Ataman and Turkey, that's...
just before we do, I mean, reading this Russian case, Terariev, it doesn't seem to be reasoned on the basis of an imminent risk to life, as far as I can see. The court is critical of the health care in the prison colony that he received over quite a long period. It obviously, it culminates in his eventually being taken to hospital and dying there. But there's fault on the part of the prison, which it doesn't seem to be put on the basis that, on an Osman basis, as you might describe it. The trouble is, in looking at these cases, there's so little articulation of what the principles being applied actually are.
Yes. So what one can draw from Terariyeva is there's no express reference to the terminology of systemic duty or the terminology of operational duty. But what there clearly is, and then it's applied in a significant number of subsequent cases, is the articulation in Article 2 terms of a duty to protect the life of those who the state is detaining.
What is that paragraph 80? Is that the court considers that in the case of a prisoner returning from hospital with a known history of medical ailments, the authorities are under an obligation to ensure appropriate follow-up care. His medical record contains no evidence that he received any follow-up care until his ulcer became perforated. Accordingly, the court finds that at the colony, he did not receive medical care appropriate to his state of health. So the implication seems to be a breach of Article 2 by the prison authorities at a stage before he's actually in imminent danger.
Yes, I accept that.
And I mean, paragraph 72, so I'm looking at the same thing. The actual complaint was in relation to the appalling conditions of her son's detention at the institutions, exacerbated by lack of appropriate treatment.
The thrust of the findings, however...
And then he's in a hospital where they don't have sufficient quantity of hemostatics.
Yeah.
I mean, that's what was striking me before about this case, that it seemed to have more of a flavour of breach of this systemic duty, which then feeds down on the facts to causally to the death.
Yes, just two observations. My Lord is right that one of the applicant's particular concerns were the conditions of detention, and there was reference to him being in handcuffs and so on. The thrust of the court's findings is about the inadequacy of the treatment, however. In terms of what approach the court was taking as a matter of principle, if the court goes to page 3037, paragraphs 73 and 74, you will see in articulating the general principles, the first sentence concludes with a reference to taking appropriate steps to safeguard the lives of those within its jurisdiction, and the footnote is to Keenan, which I've already taken the court to. And then in the context of prisoners, the court's already emphasised in previous cases that persons in custody are in a vulnerable position and that the authorities are under a duty to protect them, incumbent on the state to account for any individual injuries suffered in custody, etc. And again, the reference there is to Keenan, also to Salmon and Turkey, which I'll ensure I check whether that casts any further light.
But I mean, 74 is put in terms, isn't
yes.
it, of the systemic obligation?
That's the observation I was going to go on to make. So,
right.
so 73 appears to be making reference to the operational obligation, 74 to the systemic obligation. And it may be because they were looking at both the prison facilities and care provided within the prison or the colony, and also to the public hospital. But in any event, for my purposes, because of course if one gets before a jury in an Article 2 compliant inquest, the issue for the coroner is whether there are credible suggestions or an arguable case of breaches of Article 2. The coroner doesn't have to identify them in relation to whether they're systemic or operational. I appreciate this court has to take a more principled approach, but in practical terms, and when the jury makes its findings, the jury doesn't consider Article 2 in terms at all, because obviously the jury cannot make findings of civil liability. So the jury focuses on what the failures were. And so whether Tararieva is a systemic or operational case, it's a clear case showing duties to provide adequate treatment to safeguard those who are in the custody of the state.
there's no reason to think that the obligation, the systemic obligation to provide adequate health care for somebody who has this deceased's complaints, ailments, should be better than the treatment available to someone who isn't a prisoner but who has exactly the same medical condition. So from a systemic level, why would it make any difference whether Mr. Tarieva was a prisoner or not?
A partial answer to my lady's question, and there is reference to this in at least one of the authorities, and I will see if I can find it, is that those who are in detention do not have any means of obtaining their own health care. And so they cannot go to whichever hospital or doctor they might choose. They have only the ability to receive the health care that's made available to them by others. And there's an certain express reference to that in one of the authorities. And because, as the cases make clear, the European Court of Human Rights has recognised that there are specific obligations owed to those who are in custody.
Yes,
obligations.
Of course there are, but they're not obligations to give them more comprehensive or better health care than is available to the general population, I would have thought.
No, and that's not the standard that's applied in the cases.
I'm not sure that saying, well, prisoners can't choose which doctor or hospital to go to is a particularly good point of distinction, because most people often won't have a practical choice. They'll go to their local GP, they'll go to their local hospital, and they won't have the medical knowledge to differentiate between them and make a choice. And usually, the public healthcare system is provided generally to the public, isn't it, at a particular standard of care?
Absolutely, but none of these cases suggest that there's an enhanced standard of healthcare entitlement for prisoners over the general population. I understand entirely my lady's point, which may be that there is potentially a remedy for breach available for deficiencies in healthcare to a prisoner that isn't available to the average patient in terms of an Article 2 breach. And the way in which that is justified in the case law is essentially because there are particular duties owed to those who you assume responsibility for, you take into your care and control.
Yes, I accept that as far as the operational obligation is concerned. What I'm struggling with is whether that's also part of the systemic obligation.
Well, the submissions I'm making in relation to these authorities are directed at the operational obligation, my lady.
Is it relevant, Ms. Richards, that in the case of a prisoner, the prisoner may not have the power to gain access to healthcare at all?
Absolutely, it is.
It's not a case of choice.
Yes. If I can then temporarily leave prisoners and move to the next iteration of the operational duty as we understand it, or an operational duty, perhaps I should put it that way, an individual duty. And it's the conscript cases. There are two around 2005-2006, Killing, and then Ataman in Turkey. And I'll just take the court to one of those, to Ataman in Turkey, which is page 4245.
Just thinking about it, there's no question of what one might broadly categorise as vulnerable people having a convention right to a higher standard of health care. It's rather that because they are they may be deprived of their liberty, or they may be unable to exercise the decision-making capacities, that systems have to be in place to enable them to access proper health care, which are simply unnecessary in the case of people who are fully competent and at liberty.
Yes, and if one looks, for example, at the way in which the operational obligation has been deployed in relation to those at risk of suicide, there is no obligation in relation to the vast majority of the population on any public body to take any particular step to protect someone from killing themselves. And indeed, if someone says they wish to go to Switzerland to Dignitas to take their own life, there is no obligation on anyone to stop that. But if you have someone who is in the care of the state, there is an obligation to take steps to stop that, whether that's in prison, psychiatric hospital, voluntary patient or otherwise.
I'm sorry, you were giving us a page number for the next
Yes, so Appellant and Turkey, page 4245. It's a Turkish conscript, military conscript case. In which it was reported that the deceased had killed themselves on duty. There was an issue in the case which is not material for present purposes, that the family thought that perhaps he had been the victim of homicide rather than suicide, but that's not relevant for what we're considering. If the court goes to page 4256, you'll see the heading monitoring obligation. And then picking it up in paragraph 54, fifth line, court's task is to determine whether in the circumstances of the present case the state took all the measures required to prevent the life of the applicant's son from being unnecessarily endangered, and then reference to the LCB case, which we have in our written case. And then Article 2 may, in certain well-defined circumstances, impose a positive obligation on the authorities to take preventive practical measures to protect the individual from others or in particular circumstances from himself. So clearly there, the operational obligation. And paragraph 55, although it doesn't cite Osman, it is effectively lifted from Osman in terms of the need not to impose an unbearable or excessive burden on authorities. And then you have the express reference to Keenan at the end of paragraph 55. And then paragraph 56, the court considers that, faced with the allegation that the authorities failed to fulfil their positive obligation to protect the right to life of the conscript as part of their duty to supervise soldiers entrusted with a weapon and to prevent suicides, it must be satisfied that the authorities should have known at the time that the soldier was at risk of committing such an act, and they failed to take measures within the limits of their powers, which from a reasonable point of view would probably have mitigated that risk. And again, it's articulated in the remainder of that paragraph, essentially in Osman/Keenan terms. And then the discussion, top of page 57 again makes that clear. We have the reference there to real and immediate risk in paragraph 57 at the top of page 4257. And then the discussion 58 through to 60 looks at essentially healthcare failings, if I can put them that way. There's because of the conscript's mental state, paragraph 58 refers to assessments that have been undertaken, and then paragraph 60 refers to an omission on the part of medical staff to provide the relevant information about the medical state to the army. And so picking it up in the last sentence of paragraph 60, the authorities therefore failed in their responsibilities because they did not properly assess the fact that Mikhail Ataman was suffering from such severe psychological disorders that they prevented him from carrying a weapon. And then, in terms of why the duty extended to conscripts, we get a sense of that in paragraph 61. Conscript performing compulsory medical service. So somebody, again, who is clearly not detained, but someone who is to an extent under the control of the state. There are a number of other conscript cases. The references are given in our written case. but they don't advance the broader argument. But it's paragraph 34 of our written case that gives the references. The operational obligation was then extended by the Strasbourg Court, or applied by the Strasbourg Court, in cases where there was a risk to life from a range of physical hazards. Now, that's quite far removed from the context of the present case, so I don't propose to go to any of the authorities, but we've set them out in paragraph 35 of our written case. It's on Yildiz, Kolbadenko and Budayeva, I think respectively an explosion, a flood and a mudslide. And again, the duty is looked at largely in Osman terms. Could the authorities or should the authorities have known there was a risk, and did they do what they reasonably could have done to protect against that risk? Those are the core Strasbourg authorities which mapped out the operational obligation before we then get to the first of the two leading domestic authorities, and that's Savage and South East Essex Partnership NHS Foundation Trust. And if I can just start by inviting the court to look at that before the short adjournment. It's page 2643. Sorry, 2463.
Sorry,
2463.
Thank you.
Decision of the House of Lords.
Sorry, 2443?
2463.
2463, thank you.
So you say the Strasbourg authorities support the proposition that there is an operational duty, even if there is no risk to life, no real and imminent risk to life.
I'd say the Strasbourg authorities are really divided into two. There's the Osman line of authorities, of which Savage is an application, and the second domestic case, Raybone, is an application, and they are squarely based upon the articulation of a real and immediate risk to life. And our primary case has always rested on that line of authority, and it continues to rest on that line of authority. But there are a series of other cases, Tararayeva being the most obvious example, and then there are others, and I'll give the court the references to those in the course of the afternoon, in relation to detainees, and indeed there's one that relates to a conscript, a more recent case relating to a conscript, where the analysis has not been, at least explicitly, on the basis of a real and immediate risk to life, but has looked at whether there were such deficiencies in the care and treatment provided to the person detained that it amounted to a breach of their Article 2 rights. And that's the second way in which we put the case operationally. We spelt that out explicitly in our written case because although the real and immediate risk has always been the focus of our submissions, it seems to us, looking at the authorities, that Strasbourg has actually developed this secondary line of case law. And I should say you'll have seen from the written submissions of the two interveners that their submissions predominantly rest on the second approach, the failure to provide adequate treatment and care.
And one of the interveners suggests that if you have a deprivation of liberty under Article 5, that there is, I suppose, an operational duty to provide proper health care to the people you detain.
Yes, and certainly for those who are deprived of their liberty under the Mental Capacity Act, it will ordinarily be a deprivation for the purpose of providing them with types of care and support.
When you say with this second line of treatment, failure to provide adequate medical treatment to somebody who is detained, is there still a difference, or do you say it's inadequate if it's provided negligently?
Well, Melody, I have to say in this context I would shy away from the use of the word negligently at all, because it has a connotation within, obviously, the common law, that it doesn't necessarily have within Europe. And, of course, in relation to inquests, the culmination of an inquest will never be a pronouncement about negligence. The term that is ordinarily used in the Strasbourg authorities in this regard is about inadequate or deficient treatment or care.
I thought Strasbourg did use the word negligence.
Strasbourg does sometimes use the word negligence, yes, but not usually when it's saying that Article 2 is not engaged. Because Article 2 is not synonymous with clinical negligence.
There's a spectrum from what we saw, the description of the treatment of the deceased in some of these cases you've been taking us to, and what happened in the present case, or what happens in, sadly, many cases that one sees in the courts. But do you say that a case could amount to a breach of Article 2 even if it was substantially less egregious than what we saw in the Russian case? Yes.
Egregiousness is not the criterion. I mean, there are individual cases which that's an entirely accurate label to apply, but absolutely. And those two approaches in the case law.
So you say there's no threshold of seriousness of the failure to provide medical treatment before Article 2 is engaged?
Well, my lady, there's no express articulation in the way in which the duty is described. But if one looks at the way in which the court then examines if there are breaches, the failures that have given rise to a breach of Article 2 are never trivial failures. But they are sometimes not in themselves in isolation egregious failures. There can be a culmination or a combination of individual failures that then can add up to something more substantial.
Now, I think we've reached a point where we're going to have to adjourn. But just before we do, can I ask, first of all, what progress you're making? I appreciate we've bombarded you with questions all morning, but it's been well-intentioned, but it may have held you up.
Slower than I had anticipated, but I expect I will still finish my submissions today, and I will ensure that I do.
If I may say so, it's particularly important, I think, for us to look at Rabone.
Yes.
And also for us to see why you say that this case isn't covered by Lopez de Souza.
Yes.
And also for you to identify for the errors in the reasoning of the Court of Appeals. Very well. Well, we'll adjourn now and resume at 2 o'clock.